Hello everyone. By now you will have received back your midterm exams, and I'm sure that a great many of you are disappointed in the marks. I was certainly disappointed in the performance overall. Partial, I think, that it's an online course, and many of you have not had an online course before. Okay, so poor performance. Let's put that behind us. There is now an opportunity, as I indicated in the email that I sent to you, for you to increase your mark substantially. Instead of having a quiz worth 15% of your grade, I'm going to have a quiz worth 30% of your grade. However, this is not an easy quiz, okay? Nothing about this course is easy. This is difficult material. It's university, okay? You have to do the work. So, we're going to go over the contract assignment, and I'm going to give you a contract drafting sheet. That material is the only material that will be on the quiz. So not only is the quiz worth 30%, but it's on a finite amount of material, and so you have an opportunity to improve your grade. But it's up to you. All right, let's get going. Contract assignment grade memo. Everybody got one with their assignment, and I'm now going to explain in detail why you lost marks. And in doing that, indicate to you what lawyers do, putting in what we call boilerplate into a contract for the protection of the parties. This will allow you in the future, if you have to use a lawyer, to reduce your legal fees. If you do the contract yourself, there's dangers, but at least you'll be better prepared. On the contract assignment grade memo, the first item is correct parties, and a lot of people lost marks because they really didn't sit down and think of who the parties were and then look back at the very first lecture that I gave you, and I told you when we went over that check example that this would be important for the contract assignment. All right, the parties. Peak Performance Pontoons, Inc. is a corporation. Ben Counter doesn't say, oh, I want to buy the helmets and then give them to my corporation. He says he wants to buy them through his corporation, for his corporation. If he bought them himself and then sold them to his corporation, he's going to pay taxes on the sale or on the purchase, and then the company is going to pay taxes on the purchase. So it just doesn't make any sense. The one party was Peak Performance Pontoons, Inc., okay? The second party is not Micro Hard Computers. Micro Hard Computers does not exist. Oh, yes, it does. It's in the contract problem. No, it doesn't. Bill Gates doing business as Micro Hard Computers. Back to that example in the first class. Inc., Ltd., Corp. means that it is a corporation. Absent those things at the end, Micro Hard Computers, nothing, means that it is just a trade name. It's Bill Gates doing business under the trade name. So the contract has to be between Peak Performance Pontoons, Inc. and Bill Gates. Better still, Bill Gates doing business as Micro Hard Computers. Okay? All right, so if you got one of those wrong, you get -1. Description of the goods. Almost everybody did well here. I mean, obviously, it's a quick think helmet. 3 of them. However, there was a trap, and at the beginning of the contract precedent, it says data processing equipment. A quick think helmet that gives you an idea is not data processing. So unfortunately, if you left that at the beginning and then you described the equipment later on, there was a problem, and I took off 1/2 mark. The regarding installation didn't turn out to be a problem. Everyone handled that really well. Item number 3, PST and GST. Has anyone bought anything lately that you didn't pay PST and GST? So the contract mentions PST, but it doesn't mention GST. That means you've just sold the Quick Think helmets, and you're going to have to pay the GST rather than charging the purchaser. All right. So again, if you did not include GST, it was 1/2 mark off. Some clever people will say, wait a minute, no, businesses don't pay GST. Yes, they do. When a business buys something, they pay GST. Now, they may get a tax credit, and be refunded that money because they buy something and they use it in the sale of their business, the government would be getting GST twice, and so they don't. So you may get a tax credit, but somebody's got to pay it. And in this situation, Peak Performance Pontoons Inc. has to pay it. Payments, I cannot believe how many of you did not put any dates into the agreement. There are payments to be made on certain dates, and if you do not put in something like the down payment on November 14th, was it 14th or 16th? Down payment on November 16th, and then 2 subsequent monthly payments. How do you know when those 2 subsequent monthly payments are? How do you know when the down payment is going to be paid? All right. So for clarity, you had to put in that the date of the down payment, and then you could either indicate that the next payments were on December 15th and January 15th, 2021, or you could just say in the next 2 months following. Fine, okay? I told everyone, do your interest calculations and put them in the problem. I told you that. And in the contract assignment, it said, do that. So many people didn't give me their interest calculations. All right? So, interest, if you got the wrong interest amount, you lost a mark. If you didn't give me your interest calculations, you lost a mark. All right? But if you gave me your interest calculations and you did it incorrectly, you would not lose a mark for interest calculations because you gave it to me, okay? But you still would lose a mark for the interest calculations. In the material I sent to you, there's a sheet which shows how you work out the interest calculations, okay? I'm not going to go over that because it's not going to be on the quiz, but it is not monthly. This part is important, okay? The calculations themselves won't be on the exam, but this part is important. It cannot be calculated monthly for 2 reasons. The first is that the first payment is from November 16th to December 15th. That isn't a month, so you cannot calculate it monthly. That would be incorrect. The second period happens to be a month, but the first period payment, not a month. That's the first thing. The second and more important thing is, well, I got to give you an example. Back in 1986, 87, my wife and I had a mortgage on our house. Mortgage rates were like going through the roof. They were, we were paying 11%. 11%, okay? And they actually eventually went up as high as 18%. So it was a terrible time to have a mortgage on your house. Our interest rate was 11%, and it was coming up for renewal. We were with the Canadian Imperial Bank of Commerce, and they made us an offer. They said, you can renew your mortgage at 14%. That's a huge whack of money on top of a large sum for a mortgage. Well, at exactly the same time, National Trust, okay, a financial institution which no longer exists, made a special offer to lawyers, 13% monthly. So I told CIBC, look, I don't think I'm going to be renewing with you because I can get 13% at National Trust. And CIBC said, okay, that's fine. Then I went to the fellow at National Trust and I said, what does 13% monthly equal on a per diem basis, on an annual basis? And they said, what do you mean? You're paying 13% per month or monthly. And I go, yeah. But what's the equivalent rate? And they went, well, that's really not necessary because after all, the equivalent rate would be, 13%. Well, gosh. And I went, well, what's going on here? Okay. So I asked to see a supervisor and I said, what does 13% monthly equate to on a per annum basis? And they did another little song and dance, and they said, well, you know exactly what you're paying. You're paying 13% per month. And I said, I want to know the equivalent rate. And they were reluctant to tell me. So I went back to CIBC, and I said, what does 13% per monthly equal on a per annum basis? And they said, oh, well, it equals 14.978% or something like that. So in fact, National Trust wasn't giving a tremendous deal to lawyers. They were actually scamming them because there was nothing wrong. It's unethical perhaps, but there's nothing legally wrong with their advertising because it did say you paid 13% per month. The government of Canada did not like that. They said that's not false or misleading advertising, but it's certainly unethical. And so they passed the Canada Interest Rate Act. Okay? The Canada Interest Rate Act says if you quote in your advertising 13% per month or any other amount per month, you have to, in exactly the same size type in the same ad, indicate what that is on a per annum basis. Well, I went back to CIBC and we said, okay, we'd like to stay with you, and they were very good about it. Okay, they said, okay, you don't have to do a new application form, you don't have to pay for a house assessment and all that sort of stuff. I mean, of course they could be nice about it. They were charging us 14% per annum. Anyway, I thought I would say something nice about the banks because I generally beat up on the banks. Okay, so 2 reasons why you cannot charge on a monthly basis. Number 1 is the first payment period is not a month. And number 2, you could do it, but you would have had to put in the Canada Interest Rate Act equivalent per annum rate. All right. There is a paragraph in there called that dealt with the title to the goods, and everybody, with the exception of one student, I think, left that in. 2 students. One of them used another precedent, which wasn't mine, and that didn't have it in, and one of the person just decided to eliminate it. Why is that important? Well, let's say I'm Microhard. I am giving you these helmets to use, okay? What happens if you don't pay me? Well, I'll come back and take back my helmets. No, they won't be my helmets. I have sold them to you. They're your helmets. So that makes it a little hard for me to come back and take them, doesn't it? So you leave in this and you say title to the helmets does not pass until such time as all the payments are made. That way, if I have to repossess, then I can come and take my helmets because I haven't transferred them to you yet. All right, delivery. The contract precedent said FOB Toronto. Here's a business in Vancouver which makes the helmets here. Why would they charge you shipping from Toronto? Okay. Incidentally, FOB, what's that mean? Oh, it means free on board. No, it doesn't mean free on board. FOB is the acronym for free on board. What does free on board mean? Free on board means you send your truck to my plant. I will put the helmets into your truck. The second the helmets pass over the back of that truck onto the flatbed, you pay for the shipping, you pay for the insurance. Okay? They're at your risk. So FOB Toronto, that's a lot of money. I mean, what's he do? Make them here, ship them to Toronto, and then send them out? It doesn't make sense. So you had to change that. You could either eliminate it, which was not great, or you could say FOB point of shipment or FOB Vancouver. Okay, then there was a clause in there which almost everyone left in, with the exception of the person that used another precedent, and that is risk and insurance. Okay, I'm keeping the helmets, but you've got them. Well, I should get insurance on them, right? But you've got them. If you break them, why should I pay because you broke them through my insurance? So what you do is you say, okay, the helmets are at your risk, Peak Performance Pontoons, and you have to get insurance. We're going to get into that a little later on, but what you want to do is make sure that you say you get insurance, and you have to keep that policy in place by making me, Microhard, Bill Gates, the loss payee. Okay. All right. So there's another clause in there which everyone left in. It was default, repossession, and acceleration. Why would we leave that in? Okay, so you don't pay. I've kept title to the goods. You're in default after a certain period of time. You can put in 15 days, 30 days, whatever you want. But after a certain period of time, you're in default. That allows me to either repossess the equipment or say, all right, the full amount is due and owing, or perhaps both, all right? What's it matter, all the payments? Well, it's not too critical with just 2 monthly payments, but let's say it was 12 monthly payments. What happens if the down payment is made, but the business misses the first payment? Well, I'll sue them. For what? They've only missed one payment. So you sue them for that payment. Then you wait a month. And then you sue them for the next payment. And you wait a month. And you sue them for the next payment. And you'd have to consolidate those law cases, of course. Well, that gets cumbersome and costly. So what you do is you say, if you miss a payment, any payment, I, at my option, can say that the full amount left to be paid is immediately due and owing. That way I can sue you for the whole amount. Now, it does say at my option. So they make the down payment, Peak Performance Pontoons, and then December 15th goes by, and you think, hey, I haven't received a payment, so you call them up. Hey, Benton? Yes? Hi, Benton. You missed a payment. Oh, I'm sorry. My gosh, I forgot. Okay, I'll courier that over to you. Well, that's better than saying I'm canceling the contract, I'm suing, okay? But if you phone and you go, hello, Benton, sorry, this number is no longer in service, and it turns out the business is closed down, you want to be able to sue for the whole amount, okay? So that's why you have this acceleration clause in there. Repossession, well, those helmets, unless they're damaged, they could be resold. So you want to go and get them back. If you have kept title, you can do that. However, you got a problem. You get to the door. Hi, Peak Performance Pontoons, I want to come in and get my helmets. You can't, you're trespassing. But they're my helmets. Yes, but you can't come on, you're trespassing. What do I do? Oh, I got to go to court and get an order to allow me to trespass to get those helmets. By that time, the helmets are gone. By that time, the business is closed. By that time, you're not going to get your money. So you want to be able to go onto the property and repossess those helmets. You put in the repossession clause, because then you go to the door and you go, hi, I want to repossess those helmets. You can't, you're trespassing. No, I have the right, according to the contract, to repossess my equipment, all right? So that's why those are in there. Everybody left them in so nobody lost marks. We then get to the choice of law and form clause, which we dealt with in the lecture in Chapter 1. Why is form important? Form is important because if there's a problem, that's where you sue. Ontario law? Why would anyone leave in a clause that says Ontario law applies when both parties are in British Columbia? Okay, so you had to change that to BC law. So if you didn't change that, you lost 1 mark. Now the next one was a little finicky, okay, so I only took a half mark off of that. When we looked at the court structure for Canada, I said this is the court structure for Canada. In BC, we do not have a superior court, okay? In BC, it's generic, that diagram. So I said you had to change that and make it the Supreme Court. This contract, Ontario, it says Superior Court. BC does not have a Superior Court. We have the Supreme Court, and therefore you lost a half a mark. Now, the other thing that I was really big on when I was doing the Chapter 1 lecture is arbitration, mediation and arbitration. I said I have not done a contract in the last 10 years that I did not put a med-arb clause in. Okay, every contract should have one. Well, this is a contract. Only about 3 people put in med-arb. Okay, there was a trap here, and I didn't take marks off for it. Well, I think I took marks off, but then I gave the people that said arbitration a bonus mark. If you say all disputes shall be resolved by arbitration, and then you say we adjourn to the jurisdiction of the Supreme Court of BC, the Supreme Court judge is going to say arbitration doesn't happen, it goes to court because you've adjourned to court, I have jurisdiction, arbitration out the window. So you had to say arbitration, and you had to take out reference to the courts. If you didn't put in the arbitration clause, you lost a mark. And it's just absolutely necessary. Date, I'm just going to jump to 9, date. everybody put in a date. Okay. I mean, there was a line for date. And if you actually didn't put in the date, I think I gave you credit because you probably would date it when you signed it anyway. Okay. That wasn't a problem. Signatures, however, were. Now, the first thing is the vendor. The vendor is not Microhard Computers. It's a vendor, Bill Gates. So there should be a line with Bill Gates' name under it. And it should say Bill Gates doing business as Microhard Computers. But Bill Gates would have been fine. If that's not there, you lost a mark. The purchaser is Peak Performance Pontoons. But the signature line has to be set up on the contract drafting sheet. Okay, I'm going to jump to that on page... I didn't number the pages. On the page where it says signature lines, which is the 4th page, it shows how an individual would sign, how a partner would sign, and then on the next page it shows how a corporation signs. In this example, it's net your customers, Inc. per authorized signatory. Remember when we did the check, I went through that very specifically. When we talked about contracts, I went through that very specifically in my videos. So you had to put Peak Performance Pontoons per authorized signatory. If you put Peak Performance Pontoons per, I wouldn't take marks off, because authorized signatory is the world according to Peter Holden. I say put that in as one more way to prevent the judge from saying, oh, I think Benton Counter should be personally liable here. Okay. But the best way to do it is set it up the way I've got it on page 5 of the handout sheet. So you lost a mark there. Now, guarantors. When we did the Kiska case in contracts and when I was talking about the check example in the first class, I said, if you're lending money to a corporation and the corporation doesn't pay you, can you sue Benton Counter? Okay, Peak Performance Pontoons doesn't pay you. Can you sue Benton Counter? No, you cannot. Peak Performance Pontoons, Inc. is a separate legal entity from Benton Counter. The contract is with Peak Performance Pontoons. You can only sue Peak Performance Pontoons unless you get a guarantee from Benton Counter. Would that be fair to Benton? Well, you're lending money to his corporation. Just ask him, Benton, if your corporation doesn't pay, what happens? And if he says, well, then I don't have to because I'm a separate legal entity, then you say, okay, Benton, I want a guarantee from you. And if Benton says, well, yeah, of course we're going to pay you, then say, well, okay, then what's the problem with signing a guarantee? I only took a half a mark off there. I'll come back to the extra mark that I gave everybody. Okay, so additional information, rigging and dredge in, I think it was clause 3. Peak Performance Pontoons, you have to pay rigging and dredge. What is rigging and dredge? Remember I said, and it's in the contract problem, that if there's terms in there that you don't know, check them out. If they belong, leave them in. If they don't belong, take them out. Okay? Well, rigging and dredge, take it out. You know what rigging and dredge is? It's equipment and tackle for moving huge pieces of equipment. A helmet, you don't need rigging and dredge. Okay? So take it out. The other thing was force majeure. I think I even mentioned this when I was talking about the contract assignment. I think I said, you may, think about putting other clauses in, like a force majeure clause. Everybody goes, oh yeah, like it, but why would we? Well, maybe some of you should have checked and put in a force majeure clause, because in the COVID-19 situation, if my plant cannot give you the helmets because I cannot have workers in there making the helmets because they've got COVID-19, then the force majeure clause says the contract is suspended until such time as I can safely have your helmets made for you. That's better than having the contract canceled for non-performance or being sued for non-performance. Okay? All right. So that's the marking guide. Now, I said the mark you got when I sent you the contract assignment by email, add 1 mark to it. Why? Well, because I obviously expected too much from you when I said, maybe you should think about putting a force majeure clause in. And I obviously expected too much from you when I said, get a guarantee. So I said, okay, well, half a mark each. I'll just give you one more mark, okay? So that's the contract assignment grade memo. Let's see. I'm just checking it over to make sure I've covered everything. Yeah. All right. So let's turn to the contract drafting sheet package that I sent to you. This is material that's not covered in the textbook, but which all the instructors thought maybe we should cover. All right, form. Contracts may be oral, written, or partly written and partly oral. Okay, and they're all binding. Now, if I have a verbal contract with you, it is legally binding. It doesn't have to be in writing. It doesn't have to be signed. It doesn't have to have a sale. We have a contract. It may be a little difficult to prove in a court, but hey, I have a verbal contract with you. I may have a witness, and you don't. So the judge is going to believe me because my witness says, yes, there was a contract, okay? Oral, written, or partly written and partly oral. Parties, covered this already. Sole proprietorships, partnerships, or juridical persons, which are corporations. We have a bit of a problem here because trade names are often confused as being legal entities. Nichols Bakery on Lonsdale, for example, made the best donuts years ago. They've changed ownership and there's too much sugar on them now. But they used to be the best donuts in the whole world. Nice and cakey with just the right amount of sugar. I love them. Well, if I bit into one of those and I broke a tooth and I had to have surgery and, stuff, can I sue Nichols Bakery? No, I can't. It does not exist. It's not Nichols Bakery Inc., not Nichols Bakery Ltd., not Nichols Bakery Corp. Okay, it's just Nichols Bakery. So I have to go down to the city hall and get a copy of the business permit, and it'll say business license, and it'll say Frank Smith doing business as Nichols Bakery. So I sue Frank Smith. I have to sue a legal entity. All right. You have to be careful with trade names. Sometimes they are trademarks, but not always. So generally they're just, the way you're doing business. Okay, a company, you have to be a little careful in the real life because there's one business in Richmond, for example, which is ABC Manufacturing Company. Oh, company, it must be a corporation. No, it doesn't end in LTD, doesn't end in Inc., or doesn't end in Corp. So it's just a trade name. On the other hand, Hudson's Bay Company, big, huge organization. It is a corporation. Why doesn't it end in LTD, Inc., or Corp? As I said in the chapter on corporations, which maybe you haven't gotten to yet, they were incorporated way before we had the Company Act, now the BC Business Corporations Act, which allowed us to incorporate companies, okay? So the only way you could incorporate a company back in those days was to go to see the king. Yo, hey, big dude. No, you say, Your Majesty, I would like to be formed into a company. Hudson's Bay Company was formed in 1640 when the person went to see the king and said, I want to do the fur trade in Canada. This is going to be a huge operation. I am going to need thousands and thousands of investors. I do not want to have thousands and thousands of partners. That would just be too cumbersome. So what I'd like to do is have a new business entity called a company in which all those members own a share, but a board of directors runs it. And the king said, what a good idea. What do you want to be called? And he said, I want to be called the Company of Adventurers and Explorers. Thou art one. That's what the king says. Bingo. The company exists, okay? Today, if you could get in to see the Lieutenant Governor of the province of British Columbia and say, I want to be a corporation, the Lieutenant Governor could say, thou art one. We don't have access to the Lieutenant Governor. Okay, so what we do is we incorporate under a statute, and that's why the company name has to, or the corporation name has to end in LTD, Inc., or Corp. Marking guide should say, as required by section, I think, 24 428 of the Company Act, BC Business Corporations Act. You have that material in the lecture guide. Okay, so subject matter. Goods, services, or a combination thereof. In this particular example, it's just the helmet, so it would be goods. But it might be helmet and a monthly maintenance contract, in which case it would be a contract for goods and services. Or it might just be that you're a consultant that does marketing consulting, and then you provide some marketing advice. Then you're not providing a good, you're just providing a service. That brings us to the question of property. All right. Now, hold on 1 second. All right. Property breaks down into two categories: real property, personal property. Okay? Real property is land, buildings, and things permanently affixed thereto. So my house is real property. My lot that the house is on is real property. Together they are real property. Things permanently affixed thereto. My septic tank, it's affixed. To take it out would cause tremendous damage to the lot. Okay, so it becomes part of the real property. I have trees. Well, trees aren't permanently affixed there too, because you can cut them down. We just cut down a tree, and I spent days chopping wood. Anyway, yeah, it's part of the land. They're affixed. When you take them away, tremendous damage is done, and therefore the courts consider it fixed, okay, affixed to the land. In this day of nuclear war, nothing is permanently affixed, but the courts think that if considerable damage is done to remove it, then it's part of the property. Okay, personal property, on the other hand, breaks down into tangible personal property and intangible. They used to use the French expression shows in possession and shows in action. Why? Well, because shows in possession means something that you could possess, like a table, like a chair, like this glass, okay? Like my computer mouse. These things you can possess because you can hold on to them. That wasn't a good analogy, and we've now changed it to tangible personal property. Because, for example, a toonie, I don't know if they can actually see, yeah, there you go, a toonie, you can possess it. But how much is this worth? Oh, it's worth $1. No, it's not. The metal is worth 1/10 of a cent, but it represents value. It represents my ability to buy a Tim Hortons donut with it. So it's called tangible personal property because it is tangible, all right? It has value for what it is, okay? The chair has value because I can sit on it, relax. My mouse has value because then I can change things on my computer screen. My glass is valuable because I can drink water out of it. What about the water? It doesn't represent value. Well, it could, I suppose, but generally it's valuable for what it is. On the other hand, money is intangible because it represents wealth. I don't have $1, but I have 200 pesos. I can possess it, but that's not important. The fact is that I can buy a cerveza with that, okay? So it's intangible is valuable for what it represents rather than for what it is, okay? So, what do you got? Patents. I have a patent on a new type of mouse. Well, I can't possess the patent, so it must be intangible. Trademark, intangible. Copyright, intangible. Industrial designs, intangible. That check that we talked about in the very first lecture, intangible. Oh, wait, no, that check was worth $80,000. Yeah, that's what it's worth, but the paper is negligible. Your knees, intangible. Okay, well, what are my knees worth? If I was unfortunately run over by a car and I was in a wheelchair, I'd still be able to teach, okay? So my knees are, worth a lot to me, but in actual fact, not worth as much as a soccer player's knees, for example, if he's getting paid $1 million to play on a soccer team. What else? The contract. Okay, you've had this, this contract. Now, the contract is going to give you $30,000 payment later on. You could go to the bank and you could say, hey, I would like to assign this contract to you and get some of that money now because I need it immediately. So a contract is intangible property because it represents wealth to you. Now, jewelry. This is a little bit problematic. If a girl has gold earrings, they would probably be considered tangible because they adorn her. They make her beautiful, more beautiful. So they're obviously valuable for what they are. But the gold, if you melt it down into a bar, would be valuable for what it represents. It represents your ability to sell the gold to get money. So it's a little awkward. A painting. Well, a painting on the wall is not part of the house because it can be removed. It's not intangible because it's not valuable for what it is. It's valuable because it's what it does. It's art. Unless, of course, it's like the Mona Lisa, in which case it has value far in excess of what it is, and therefore it would be intangible. The next thing in the thing is chattels. It used to be that we called tangible personal property chattels. If you could get a mortgage on land, it was called, it's just a mortgage. But if you had a chattel, like a whole bunch of business equipment, you can't get a land mortgage on it, but you could get a chattel mortgage on it. Now we've eliminated that term and don't use it very often at all because we've replaced that chattel mortgage with something more modern. Okay, so an assignment clause in a contract will allow the party to either assign it, which means I can take this contract to the bank and assign it for money, or it may prevent an assignment. In here, this is a contract for a distribution agreement, the assignment clause on page, I think, 6. It says, this agreement shall be binding upon and inure to the benefit of and respective parties, etc., blah, blah, blah. But it is personal to the distributor who may not assign it. So I gave distribution rights to Dilbert Dabble, because he's a great salesman. I do not want him to turn around and assign it to Myron Entwistle, who couldn't sell anything. Okay, I want Dilbert Dabble to perform the contract, so I prevent him from assigning it. Dilbert Dabble is going to get equipment from me. Well, I'm the manufacturer. Dilbert Dabble doesn't care if I assign manufacturing rights to 3 other different businesses, as long as he can get the helmets, okay? So you can use the assignment clause to fit the needs of the parties. The next item on the list is boilerplate. Okay, I'm just going to put it on hold for a second here. Sorry for the interruption. I was hoping to get a cup of coffee, but my daughter hasn't made any, so I'm stuck with water. I'm going to talk about boilerplate clauses. Lawyers use that term. Oh, we're going to put in some boilerplate clauses. And they were sort of shooting themselves in the foot because customers thought, oh, they're putting in all these extra clauses because that way they can bump their bills up. In actual fact, boilerplate clauses, if you know what boilerplate means, boilerplate was plates of metal that they would rivet around a steam engine because the steam would get so hot that it would explode, and so the boilerplate would hold it together. So lawyers talk about boilerplate as those clauses that hold a contract together. So one of them is the inurement clause, and I just touched on that in the assignment clause earlier on, but you can have a separate clause. Inurement, all the terms and provisions of this agreement shall inure. Okay, that's not a typo. Inure means for the benefit of. So we have a shareholders agreement. It says when one of the parties dies, those shares must be sold back to the corporation by paying the estate. Well, a shareholder dies, their estate gets the shares. I might want to keep the shares in Starbucks, or I might want to keep the shares in Microsoft. I don't want to have them sold back. And so you, as the owner of the business, wind up having other people own shares that you don't want. So you put in this clause, and then in the shareholders agreement it says the shares have to be sold. Well, okay, a departing shareholder has to sell the shares back. But if a shareholder dies, the representative is bound by this agreement and must sell the shares back. Okay, so that's what the inurement clause goes. The counterpart clause, Peak Performance Pontoons is in North Vancouver. Gil Bates is in Vancouver. Not a problem signing the contract, really. One of the parties can drive to the other place and sign. No problem. But what happens if one of them is here and one of them's in Detroit? Okay, it's a little awkward to get together to sign the contract, so you put in a counterparts clause. This agreement may be signed in two or more counterparts, each with which when signed shall be deemed to be an original, and the counterparts together shall constitute one and the same instrument. So I get 2 copies of the agreement. The person in Detroit gets 2 copies of the agreement. I sign both of these. That other person's signature isn't on these. He signs those. My signature isn't on those. He sends one of those to me. I send one of mine to him. Now I have 1 copy with my signature and 1 copy with his. Together, that's the contract. He has one with his signature, one with mine. That's the contract. That's what counterparts means. Interpretation of contracts. There are express terms and implied terms. An express term is, I will pay you $38,950. An implied term is a term that, had we thought about it, we would have put in the contract. Okay, this comes from the SS Lotus case. No, not SS Lotus. The SS Moorcock case. On the top of my family crest, there's a moorcock. It's a very important English bird for some reason. I have no idea. Anyway, the SS Moorcock was a ship. It's coming into a harbor. It contacts the wharfinger, the guy that runs the wharf, and it says, she's 48 feet long and she has a 3-foot draft. Can I tie up to your dock? Why would he say 3-foot draft? Well, because that means when the tide goes out, the ship lowers, and he wants to know that there's at least 4 feet of water underneath the dock. Otherwise, his ship's going to hit the ground. The wharfinger says, sure, tie up. They tie up the SS Moorcock, the tide goes out, the ship goes down, a big rock pokes to the bottom, and it sinks. There was a lawsuit. The wharfinger says, hey, I said he could tie up. I didn't say it was safe. And the judge said, whoa, no. She's 48 feet long. She's got a 3-foot draft. It's an implied term when you say, sure, you can tie up. That sure, you can tie up. It's safe to do so. Okay? So an implied term is a term not expressly stated or written down, but which the parties would have reasonably included had they considered it. Okay. It's not really a problem in this contract that you did, but let's change the scenario a bit. Let's say you're buying 3 of these helmets, and the light bulbs are not just 40-watt bulbs. They're really special. Okay. So you say, I will buy 3 helmets with light bulbs if you give me 3 spare bulbs for free. And you say, sure. Okay? And you get the helmets. Well, no, we sign the contract, right? And you look at the contract and you go, okay, well, wait a minute, Gil. it says here that I get 3 helmets with light bulbs, but it doesn't say about the 3 that you're going to give me free of charge. And Gil says, but why would we put it in the contract? You're not buying them. This is what you're buying. And you go, oh, okay, yeah, right, that makes sense. And so we sign the contract, you give me the down payment, I give you 3 helmets, but I do not give you the 3 extra bulbs. And you call me up, hey, Gil, what about the 3 extra bulbs? Oh, well, they're very expensive, so I've decided not to give them to you. You're going to have to buy them. And you go, wait a minute, whoa, wait. It was part of the deal. And you go, no, it was a gratuitous promise. I'm giving them to you. I'm not getting anything back. This contract has consideration going both ways, so it's not part of the contract. And you go, no. I would not have signed this contract had you not agreed to give those to me. The problem with that is you're not going to get the bulbs. Why? Because there's this thing called the Parole evidence rule, a term previously orally agreed upon between the parties shall not be allowed to add to or used to contradict the written contract. Okay? When you reduce a contract into writing in a formal manner, the courts take the position that that's the contract. Nothing he says, nothing she says, nothing they say can be used to defeat that contract. They do that for certainty of contracts, right? Parole means extrinsic to or outside the contract. And we now, lawyers, because people get caught with that, we now put in what's called the entire agreement clause. I'll come back to that in a minute. But let me give you an example. I had a very good client, a young fellow, a mover and shaker in Vancouver. I don't know, you probably don't know the entertainment coupon book, but there used to be this book of coupons, and it was really thick, and it had coupons for a huge number of restaurants and for replacement of mufflers and for tire rotations and all sorts of things, so that people could use the coupons and save money, and you'd buy the coupon books. He started that, okay. So he was an up and comer. Well, his father, unfortunately, got into some problems. His father was a driver mechanic for a budget rent-a-truck. It was his job to maintain the trucks and then move them around to the various locations in the Lower Mainland so that there was trucks available. He got his 3rd drunk driving conviction, and the business fired him. Okay, so now he's got a mortgage on his house and car payments, but no job. So the son, who's a mover and shaker, thinks he's going to help his dad out, and he gets his dad to sign a contract to purchase a fish and chips restaurant. And he brings the document into me. He goes, Peter, and he was feeling really good because I don't know what it's like with young ladies, but young men, when you get to the point in life where you can actually do something for your father that your father could not do for himself, it makes you feel really good. Okay, I remember when I did that, I thought, I helped my dad out. All my life, my dad's been helping me, but I finally got to help him out. It made me feel great. So anyway, this guy comes in, he's feeling really great because he's helping his father. And he says, Peter, we've got this contract. We'd like you to handle the purchase. And I looked through it and I thought, there's a problem here. So I said, there's no indication of financial statements in there. How do you know that fish and chips shop is even making any money at all? And he said, oh, don't worry. And I said, no, I'm a lawyer. It's my job to worry. So there's no financial statements. How do you know it's making money? And he said, oh, they told us it was. And I went, oh, whoa, wait a minute. I said, how do you know they're telling you the truth? His answer to this was, oh, don't worry. They're from the same ethnic background as us. My client was from an East European country. The vendors of the fish and chip shop were from that same East European country, so they would not lie to him. So I said, well, okay, you've already signed it. You've already paid the deposit. I will handle the purchase for you. But I sent my client, this son, well, actually the client, a CYA letter, a cover your letter. And in there I said, I am handling the purchase, but I was not involved in the negotiations, and I want to point out to you that there's no financial statements attached, so you have no idea whether this shop is making money or not. My client calls me up and he says, no, don't worry. The vendors have, they're looking in the basement. They're going to find some, tape, register tapes that'll show, how much it was making. And I said, okay, well, it's, too late now because you did not get to your lawyer in time. You signed the agreement first. They buy the restaurant. People are staying away in droves. It's not making any money at all. And the young man's back in my office and he says, I want to sue them. Okay. I said, you can't. I said, because 2 reasons. Number one is the parole evidence rule. Okay. If the sales was an important matter, it should have been put into the contract. And number two, they put in an entirement agreement clause, which is the parole evidence rule in writing. Okay, the rule applies whether there's an entire agreement clause or not, but we generally put in the entire agreement clause because that will twig in the people's mind that if there is something like free light bulbs, or if it is important that a restaurant is making money, that information should go into the contract. Okay. Okay, that's East European country. Okay, no one else would ever cheat on anybody, would they? I had another client come in, a lady, and she was Japanese, and she wanted to buy a travel agency. There was a firm in town that had that sold Japanese tours. Okay, tours to Japanese people to come over and see the Rockies and visit Vancouver and stuff. And the owner had 11 people working, 9 to 5, 5 days a week, selling these tours. The business was making money hand over fist. He wants to sell, it's a corporation, okay, so he's the sole shareholder. And he wants to sell the corporation to my client. My client comes in and says, I want to buy this. And I said, well, my advice is do not buy a corporation. Because if there's contingent liabilities that we don't know about, you buy the corporation, you get the liabilities. Okay, they don't go with the vendor. Okay, he's a separate person from the company. You keep the company. And she said, oh, well, he's Japanese and he's going back to Japan, so he doesn't need his company and he wants me to buy it. And I said, well, don't. Just buy the assets. Don't buy the corporation. And she said, no. He is a very honorable person. He will not cheat me. And I went, okay, I've heard this before. And so I said, all right, you've signed the deal. You can buy the corporation, but again, I did a CYA letter, and sure as heck, she bought the business, and it was making money hand over fist. So what's the problem? Well, the problem was the first month she pays her GST. Okay, and the tax department comes and says, okay, we've watched this company pay its taxes for years, and all of a sudden, what happened? Why all of a sudden was a GST payment so substantially larger? It turned out that he was not paying the right amount of GST. It's a honor system. Okay, the tax department cannot check every business in the country, so they presume that you're being honest. Okay, and he wasn't. She bought it, paid the right amount because she's honest. He's gone back to Japan, and she wants to sue me because I should have told her not to buy the corporation. Fortunately, I had put it in my letter. She actually got to another lawyer, and that lawyer sent a letter and said, Peter, contact your insurance company because you are going to be sued for negligence. And I sent him a copy of my CYA letter, and I said, no, I told her not to do this. The lawyer calls me up and he says, okay, I'm sorry. Yes, you did the right thing. I'll tell my client she's just out of luck. Okay, so that's the parole evidence rule. Now, Japanese, Eastern European, American, Mexican, it doesn't matter. Okay, most people are honest, and if you're entering into a contract, I think the presumption has to be that the other party is honest. So if you say, okay, I'd like to buy 3 helmets with light bulbs, and I want you to give me free of charge the other 3 bulbs. And you get the contract, and the other 3 bulbs aren't in there. You say, hey, Gil, the other 3 bulbs aren't in here. And if you start saying, well, yeah, I know, but I'm giving those to you, and this is what you're buying, so it doesn't have to go into the agreement, then little red flags go up, okay? And you say, okay, well, it doesn't have to, but why not put it in? Like, it doesn't hurt anything. And I think it's important. We're in a rush here, and I'd have to retype the agreement. Little red flags go up. Don't do it. Okay. So that's the whole concept of parole evidence rule. Civil law does not have the parole evidence rule. That is a common law doctrine. Okay. All right. Condition precedent and condition subsequent. Condition precedent is a term of a contract which must be satisfied before the contract is final and binding. You want to buy a house, but you don't have enough money, so you have to get a mortgage. If you get the mortgage, you start paying mortgage payments, and you haven't found a house you want yet. So you go out and you find a house, and you want to buy it, but you don't want to put the deposit down in case you cannot get your mortgage. This is what you call a catch-22, right? So you put in a condition precedent. You put a clause in the contract of purchase and sale for the house says, this agreement is binding only once my condition precedent is removed. And the condition precedent would say, this contract is subject to my ability to be able to get a mortgage from the Bank of Montreal at 3% interest over a 5-year term by such and such a date. Okay, and so you put that condition precedent in there. Now you can know that you've got the house, and you can go out and get the mortgage. And if you can't get the mortgage, then the contract doesn't become final and binding. That's not fair to the vendor. Okay, now I've got my house sold, sort of, pending this person getting a mortgage. But what happens if between the time that we sign the agreement and getting the mortgage, somebody walks up and says, hey, this is a full cash offer, no mortgage, I want to buy your house? That's a lot better than waiting, okay, because okay. So you put in a condition precedent, okay. You say that in the event that I get a better offer, then you have 72 hours to remove your condition precedent, or I can cancel the contract. So condition precedents can work both ways. Very common in real estate transaction. A condition subsequent, though, is a term of a contract which provides for the future uncertain event, the happening of which brings the contract to an end. I like football and hockey. Okay, so let's say Buddy and I decide to go to a Vancouver Canucks hockey game. So we go out for dinner beforehand, we have a couple of beer, and then we get to the game early because we want to watch the teams warm up, and we have a beer, okay? And then during the first period we have a beer, and then between the first period and the second period we have a beer, and during the second period we have a beer, and during the third period we have a beer, and then midway through the third period we're in the stands going, go BC Lions, go! Go BC Lions, go! BC Lions are a football team, but we're so drunk we cannot remember that we're at a hockey game. Well, the attendants come along and they kick us out. We paid a huge amount of money and we have a contract to watch the game. How can that contract come to an end? Well, there'll be a condition subsequent clause in there that says if you're rowdy, drunk, or whatever, they have the right to bring the contract to an end and kick you out. Okay. The Pacific National Exhibition puts on a circus and things like that. And they have a clause in there that says we have outside venues, which if it rains, will be canceled. But your contract will not be canceled. Okay. But the condition subsequent is that they don't have to do those outside venues if the rain pours. Okay, so those are condition precedent, condition subsequent. Now, signature lines. This will be on the quiz, this will be on the quiz, and by the way, this will be on the quiz. Individuals, this one is Dagmar Francine. Okay, it could be Peter Holden, it could be Gil Bates. Okay, where it says individuals, colon, that does not go on the agreement. It would just be the line with Gil Bates, okay, or Gil Bates doing business as Microhard Computers. And then they sign. Bingo, you got them. Partnership, let's say it's Gil Bates and Dagmar Francine that run Microhard. It would be better to get both signatures in case there's a dispute between the partners, but it doesn't matter because either partner can sign. So how do they sign? Dagmar Francine, partner. Okay. Corporations, however, Net Your Customers Inc. or Peak Performance Pontoons Inc. sign that way. Strictly speaking, a signature line consists of the corporate name with a line that says per, which means on behalf of. However, the word in the world according to your instructor, be safe and put authorized signatory under there, because that's one more indication to the judge that you are signing on behalf of the corporation and not for yourself. Well, am I the authorized signatory for me? No, I'm me. So if I put authorized signatory, I must be signing for someone else or something else, okay? It has to be that way, okay? Now, I had a client who signed a franchise agreement, and I told him to set it up this way. And I said the signature line has to be underneath the corporate name. Well, this guy, the corporate name was on page 1. On page 42 of this franchise agreement was a signature line with just his name under it. And he said, oh, okay, the signature line is underneath the corporate name. No, it's got to be right underneath the corporate name. So the corporate name should be on the front, and on the signature page, set up that way. Now, in the assignment that I gave you, you get to the bottom and it says signature lines go here. Why didn't I put in the signature lines? Because I don't know whether the contract precedent is going to be used for a sole proprietor, a partner, or a corporation, or two corporations, or whatever. So I said signature lines go here. That's why I very clearly said, make sure you set up the signature lines. Okay. All right. Guarantee. Sometimes the party you're dealing with has the upper hand and requests that you sign not only on behalf of your corporation, but also personally. So there'll be another line, the name of the guarantor underneath it, and a red seal on it. Remember, the seal has to be on the contract before or at the time the contract is signed. I have a client, Sylvan Learning Centers. I think I talked about it in the video. Had 4 locations, had to sign 4 leases. Every time the landlord said, I want you to sign a personal guarantee called a covenant. My client said no. They said, okay, we'll take your corporate signature only. When the lease came out, there was a place for the corporation to sign, and then there was a line with my client's name and a red seal beside it. My client always got to his lawyer on time. He would call me up and he would say, I don't understand. Why is there a line there for me to sign? I signed up here for my company and I have to sign again. And I said, well, that's a covenant. That's a personal guarantee. And he said, well, that wasn't part of the deal. And I'd call up the landlord and I would say, how come it's set up that way? You know from the offer to lease that that's not supposed to. Oh, well, gee, gosh, these things happen. I did the deal and I give it to my staff and they fill out the lease. And this is the way we usually do it. So they just did it that way and sent it out. And I'm going, yeah, right. Had my client signed it, and then 2 years later, his company went insolvent, the landlord would sue him, and he would say, hey, wait, that wasn't part of the deal. And the judge would go, hey, wait, why did you sign it then? Okay? So you have to be really careful about that. All right, second to last thing, is security for payment. There are a number of things you can do. This list isn't exhaustive, by the way. There are probably other things, but these are the key ones. There are things you can do to ensure that you're going to get paid. Okay, well, no. Let's back up. There are things you can do that give you a better chance of being paid. Okay? If a company goes insolvent, it doesn't matter what you do, you're probably not going to get paid. If a guy is slippery and he's trying to defraud you and he skips, you're not going to get paid. But most people are honest, okay? And so you should do everything you possibly can to ensure that you get paid. Because COVID-19 lots of businesses failed through no fault of the owners, okay? And so there are times when you want to do everything possible. Some of these things are mutually exclusive. Some of them you can do together with others, all right? The first one is a retainer, all right? I'm a lawyer. You come in and you say, I want you to do a shareholders agreement for me. I say $1,500. Pay me now. I've got the money in my trust account. I do the work. I bill against it, okay? I don't have any bad debts. Well, most people cannot do that, okay? But like Microhard Computers, or I should say Gil Bates, he said, sure, I'll sell you the helmets, but you have to pay me a down payment. Okay, so he gets $8,950 up front. That's going to take a lot of the sting out of not being paid later. Retain title to the goods. We already talked about that. You want to make sure that you have title of the goods, that you haven't transferred it to Peak Performance Pontoons, and that will allow you to repossess later. The acceleration clause, which says repossess and declare that the entire amount becomes due and owing, means that you do not have to wait until default occurs on all the payments, that you can demand and sue for the full balance. Doesn't mean you're going to get it in court, okay? You sue for the full balance. It's it's going to take 2 years to get into court, and they may be insolvent and everything's disappeared by then. You get a dry judgment. I mean, even if you have an arbitration clause and you get into arbitration in 3 months, a lot can happen in 3 months, okay? But at least you have a better chance. All right. The next one, file a financing statement under the Personal Property Security Act. Remember I talked about chattel mortgages? We don't have those anymore. You get a personal property security instrument under the statute, the Personal Property Security Act. So what that means is I have 28 desks and chairs and computers and cabinets and photocopying machines and everything. I own them all, okay? And I want to borrow some money. Well, you say, okay, I'll lend you the money, but I want some security. And you go, well, I've got all this stuff. And you go, okay, but how do I take it as security? Okay, well, I file a financing statement, which I list all those items, and I say I have a first charge on those. Okay, if he does not pay me, I get to come in and take that equipment back, or pardon, not back. It's not yours. Take that equipment away. You file a financing statement. This is not a financial statement. A financial statement is an income statement, balance sheet, cash flow statement. A financing statement is a government form. It's about a 2-page thing. You just list the parties, you list the things that are being taken as security, and with other details. You pay a fee, and then you're in a registry system in Victoria in the government. And this business doesn't pay somebody else, they cannot come in and grab that equipment. Well, they can, but they better not, because they should check and say, whoa, somebody else has a charge against that equipment. We cannot take it, okay? All right. This gets a little complicated because sometimes you go to the bank and you say, I would like to buy $80,000 worth of equipment. And they go, we can only lend you $40,000. So you go, oh, okay. And then you go to me, and I'm the person that's going to sell you the equipment. And you go, look, if I pay you $40,000, will you give me the equipment and take a personal property security instrument? And I go, $40,000. Well, that's good. That's half. Sure. Okay. The problem is the bank lends you the money, $40,000, which you give to me. They want a personal property security instrument, so they register their security instrument. Now, I want to take a personal property security instrument, but the bank has already got one there. Can I do it? Yes, I can. I will be in second place to the bank, but at least I have some protection, okay? Because generally people pay off the bank before they pay off other people. So they pay off the bank. The more they pay off the bank, the better I am for selling it to you, okay? All right, letters of credit. I am selling Peak Performance pontoons to Australia. I want them to pay me. They go, I'm not going to pay you until you give me the skis. And I go, I'm not going to give you the skis in Australia before you pay me. Well, we have a problem here. Okay, who's going to let go first? And so what I do is I say, okay, I get a letter of credit. Go to your bank, get a letter of credit. So that G'day Mate in Australia goes to the bank and they say, okay, give me a letter of credit. The letter of credit is sent to my bank and my bank tells me, okay, we got this letter of credit. What that means is the business in Australia is not going to pay me anymore. The bank is going to pay me, okay? So I go, all right, I know I'm going to get the money, okay? So now I can ship the skis. As soon as I ship the skis, G'day Mate knows they're going to get the skis, and I'm going to get paid by letter of credit. What happens if I ship the skis and the ship sinks? Insurance takes care of that. G'day Mate cannot go to the bank and say, hey, I'm canceling the letter of credit. Okay, as long as you make it irrevocable, the bank is obligated to pay out. Okay. Even if Peak Performance Pontoons fraudulently did not send the skis and sent an empty container instead, the bank has to pay out. G'day Mate then has to sue Peak Performance Pontoons. Not that they would do that, but it guarantees payment. Okay, so it's just a very good way. So for example, on the exam a couple of years ago, I had an insurance scenario, and you had to decide whether you're going to get insurance, and one of them is credit insurance. I have $180,000 in receivables. Some of those aren't going to be paid. Some of them will be bad debts. So I have credit insurance for that. But what happens if I don't have accounts receivable because I get paid by letters of credit? Then I don't need credit insurance, do I? Okay, because I'm guaranteed to be paid. Insurance, well, wait a minute. If we've done all this other stuff, why do we have to worry about insurance? Because you never know what's going to work and what's going to fail. Okay, so Gil Bates is giving 3 helmets to Peak Performance Pontoons. $30,000 is going to be paid later. So Gil Bates says to Peak Performance Pontoons, get insurance. If the helmets are destroyed, if the helmets are stolen, you get the insurance money, you're still going to be able to pay me. Okay, so, I think I'm going to sneeze. No, sorry. Pardon me. Get insurance. Why should I make them Peak Performance Pontoons get insurance? Because they've got the equipment. They're using the equipment. If it's damaged or stolen, it's because of something that they did. So I want to get paid. But what happens if I get them to get insurance and they go, yeah, Peter, see, we got her. I'm Gil Bates, sorry. Gil, we got the insurance. I go, oh, great. Well, Peak Performance Pontoons, if they get into financial trouble, could always turn around and sell that insurance policy back to the insurance company to get some cash. The helmets are stolen. I go, hey, pay me with the insurance. Peak Performance Pontoon says, well, sorry about that. Gosh, the insurance policy was canceled. So how do you protect yourself against that? What you do is you get them to designate you, Gil Bates, as the loss payee, which means that $30,000 of insurance is going to go to Peak Performance Pontoons if the helmets are stolen or damaged, right? But they've already paid me some money. So I'm only owed a portion of that, okay. But at least that way, the loss payee means I'm going to get it. If I'm not on there, they can cancel the policy. But if I'm not on there as a loss payee and Peak Performance Pontoon says, hi, insurance company, we need some money, cash, really fast. We're going to sell this policy back to you. The insurance company goes, but there's a loss payee on there. We better phone Gil Bates and find out if this is okay. All right? So you can protect yourself that way. And then the last thing is just get a personal guarantee if you're dealing with a corporation and you're lending them money. Okay, so there's 10 things you can do. I'm going to ask you to list and briefly explain some of those on the quiz. And then the last thing is something I've added this year that wasn't in there last year or the year before, and that's what about a pandemic? A force majeure clause is put in there to, rather than have a contract canceled because one of the parties is unable to perform through no fault of their own, the contract will be suspended. So let's take an example. I'm a trucking company, and I am going to I have a contract to deliver a whole bunch of stuff to you. And there's a fire and my trucks are destroyed. Well, the contract comes to an end. You've paid me some money, too bad. You need the goods, you're going to get sued, too bad. The contract comes to an end, okay? Because through no fault of my own, I'm unable to perform. What happens if I can't perform, so I burn the trucks? Well, hopefully I'll be caught, okay? And then because I caused the problem, the contract is still valid and you can sue me. So if the contract cannot be performed through no fault of my own, I do not want the contract to be canceled. What I want to say is, okay, wait a minute, no, look, I can go out and I can lease some trucks and I can get the stuff to you, okay? But it's going to be a bit of a delay. If I have a force majeure clause in there, I can do that, okay? Because that prevents the contract from being canceled. It's merely suspended until I can perform. If I cannot perform, I hope to, but I cannot, then eventually the contract can be canceled, right? Now, the thing about the pandemic is people had force majeure clauses in there. And so what you do is you go here and you say, okay, what does it say? Well, it says if I cannot perform because of fire, explosion, war, riot, strike, walkout, labor controversy, flood, shortage of water, power, labor, transportation facilities, and necessary materials. Oh man, it doesn't say COVID. Default or failure of carriers. Oh wow. Breakdown in loss of production, anticipated production. Oh, wait a minute. Okay. COVID caused that. Breakdown in or the loss of production or anticipated production. Maybe it's covered, maybe it isn't. Because you could actually move your staff around and still produce, okay? So this probably wouldn't work. But if you put in or pandemic, force majeure clause will protect you, okay? So you need a force majeure clause in most contracts where you're producing something and you may, through no fault of your own, not be able to do it. But you better make sure that you get a lawyer to draft it. All right, so that's everything. The quiz will be on June 17th. I will provide you indication of how long you have. I think I said a half hour. If you come in and you think, I'll just look stuff up, you may be in trouble, okay? But if you come in and you've studied, I think that a half hour would be more than adequate, all right? It's worth 30%, not 15%. This gives you a chance to pick up ground. It is not necessarily easy, but it does provide you an opportunity to better your grade. Okay, if there are any questions on that, you just email me, please. I do not get enough emails from people, and I always worry that things aren't going as well as I hope. And from the marks in the midterm exam, I think I was pretty much correct on that. So that's it. And again, email me with any questions. Thank you.